had asked me to talk today about a very broad topic, justice and injustice. And so what I thought I would do is talk about justice and injustice in Texas. And in particular, I wanted to talk about how I think there are several developments that are leading us to a greater degree of justice in Texas. And that's really what I wanted to pursue today, is those developments that I think are leading us to a greater level of justice in Texas. One of those developments, dealing with the criminal justice system, deals with the prison system in Texas. And remarkable things are happening with prisons in Texas. In the 1980s and in the 1990s, we couldn't build prisons quickly enough. The idea in Texas in those days was lock them up and throw away the key. We built 100,000 new prison beds. The inmate population quadrupled in that period of time. And in the 2000s, the Texas legislature began to recognize putting people in prison costs money. It's really expensive. And so the issue became, do you build more prisons or do you reduce taxes? And the answer, of course, was we reduce taxes. And so at the time, there was a Speaker of the Texas House of Representatives named Tom Craddock. And Tom Craddock appointed a state representative who actually was the state representative in the Richardson-Plano area, named Jerry Madden, to head a committee. And he told Jerry Madden, don't build new prisons. They cost too much. And that led to a real change in our prison population. By 2007, Texas was faced with spending an additional $2 billion on prisons and building 17,000 new beds. And it was already spending $3 billion a year on prisons. And so what Jerry Madden, working with a state senator who's still in the state senate, named John Whitmire, they worked together and they decided to put together a kind of prison reform package where they invested in treatment programs and diversion programs, things like halfway houses, as opposed to putting people in prison. And the result is the level of incarceration of people in Texas is down. The prison population is stabilizing. Probation revocations are down. Parole revocations are down. Recidivism rates are down. That is the rate of people who are going back to prison after they've served time in prison. Texas recently was even able to close one of its prisons, the old Sugar Land prison, which was just an ancient prison. But this should give you an idea of what has been happening in terms of prison reform. In 1980, there were 30,000 inmates in Texas prisons. In 1990, 49,000 inmates. 1997, look at that jump over a 7-year period. 1997, 130,000. 2000, and the year 2000 is sort of where we maxed out. A little more than 150,000 people in prison. 2012, we start dropping down to 137,000. Now it's about 134,000. We're approaching the 1997 level of people in prison. So we're dropping, and we seem to be stabilizing sort of at around 130,000 people in prison now. But I think this is a dramatic change. And one thing to keep in mind is once you go to prison, you're going to prison on a felony. Once you go to prison and you go to prison on a felony, life becomes pretty hopeless. It becomes hard when you get out to have any sort of future in terms of job, anything like that. So the fewer people we put in prison, the better life is for Texans in general, and for these people who are not being put in prison because there are alternative processes for them, like halfway houses, for example, or like probation, as an example. By the way, just as an aside, Ruiz versus Estelle in 1980 was probably the most important prison reform case, not only in Texas, but I think in American history. It was a case filed by David Ruiz against the director of the prison system, whose name was Estelle at the time. And it challenged a lot of prison procedures. Just to give you an idea of what Texas prison procedures were like back then, prisoners ran the pharmacy in prison systems back then. Unlicensed doctors treated patients in the Texas prison system back then. There was a special provision allowing people who couldn't get medical licenses to practice in our world, to practice in the Texas prison system. At nights, prison inmates provided medical care to other prisoners. And in some cases did things like amputations. So there was really a need for reform in the Texas prison system with Ruiz versus Estelle, but a major prison reform case coming out of Texas. The other big thing that's happening, and it's happening right now, and it's happening primarily in Harris County, where Houston is, and Dallas County, where we are. It's money bail, requiring money to get out of jail. It's been challenged in 10 states, but the big important case, which is O'Donnell versus Harris County, is of course a Houston case. It's the important case because it involves such a gigantic county as Harris County. But it's basically declaring that requiring money bail for indigents is unconstitutional as a violation of due process and equal protection of the law. If there is evidence you will return for trial without paying money bail, this court decision says you should be released on your personal recognizance, where you essentially are promising to come back for your trial. A very conservative Chief Justice of the Texas Supreme Court, currently a Chief Justice of the Texas Supreme Court, Justice Nathan Hecht, said this recently. 25 years ago, 1/3 of the jail population was waiting trial. Now, 3/4 of the people in jail are not in jail because they're being punished. They're in jail waiting trial. 3/4 of the people in Texas jails are just there waiting for their trial. And Chief Justice Hecht said most of those are not violent, they're unlikely to reoffend, and they pose no risk of flight. Why are they in jail? Because they're too poor to make bail. Is that an injustice? Well, I think so, and apparently a federal district court in Houston thought so, and a federal district court in Dallas just more recently thought so, and declared money bail for indigents who could appear for trial without paying bail, declared that money bail to be unconstitutional. Just look at what Texas has been doing in terms of jailing people. If you were arrested on a misdemeanor, Class A or Class B misdemeanor, you wouldn't go to jail on a Class C misdemeanor. Class C misdemeanor is like a speeding ticket. Class B would be possession of less than 2 ounces of marijuana, for example. Class A might be an assault case or an intoxication case. In Harris County, in 2015, before this court decision, 50,000 people were arrested on those misdemeanors, and only 2% were released on personal recognizance. The rest had to pay money bail. There are studies that show there's no difference as to whether someone shows up for trial, as to whether they pay money bail or are released on personal recognizance. So the court is saying, well, why require money bail? Well, in Harris County, about 150 people, more or less, every day are arrested and jailed because they can't afford money bail, but they have a job, they have a residence in the county. They could be released on personal bond, but they weren't being released on personal bond. And this is what happens to you if you wind up in jail rather than being released. Look at the conviction numbers. Overall, 68% of the people arrested in Harris County were convicted. If you wound up in jail, 79% were convicted. If you were released on personal recognizance, 55% were convicted. What's the difference? Why the difference? Well, could it be that if you're released, you can work to help your case out? It's much harder to help your case out if you're sitting in the Harris County jail. If, in terms of being sentenced to jail time, overall, 58% of the people in Harris County were sentenced to jail. But if you were kept in jail, waiting trial, 75% got a jail sentence. If you were released on personal recognizance, only 40% got a jail sentence. You were much more likely, if you were released from jail, you were much more likely to get probation, as you can see. Much more likely to get probation than jail. So this Harris County case and the newer Dallas County case, I think are really a move toward justice in Texas. It's a way of really changing conditions of life for people who are lower income people, for indigent people. Another thing Texas laws have done is they just created criminals. And let's pursue that a little bit with an issue that is near and dear to the hearts of at least some of my students at the University of Texas at Dallas, and that is possession of marijuana. Let's suppose you are arrested for possession of a joint, for possession of a marijuana cigarette in Collin County, just right down the road, literally. What would happen if you were arrested in Collin County? You would spend the night in jail. If a vehicle was involved, that vehicle would be towed and impounded. You would probably have to pay, you'd have to pay $500 bail to get out of jail. And when you went to trial, this would be a Class B misdemeanor. When you went to trial, you would probably be fined $500. This is kind of the norm, more or less. You would be fined $500. You would be required to do 30 hours of community service. You would be required to pay for and take one of the most stupid drug education classes you can possibly imagine. You would get a year's probation where you would have to go and report regularly to a probation officer and do a urine test with the probation officer, and you would lose your driver's license. So, which basically meant that you would have to go to court to get a judge to allow you to drive to and from work. And you'd have to, of course, get an SR-22 insurance policy, which means you'd pay much more for automobile insurance. If you hired an attorney, that would be another $1,000 to $3,000. The total cost could easily, for that marijuana cigarette, the total cost could easily run $5,000 to $7,000 would be added everything in. Is that just creating criminals when you punish someone for smoking a marijuana cigarette, something that is a very, very common practice? Well, what is happening in a number of counties, not Collin County, but a number of counties, is something that I think is moving us toward justice, something that is changing things. We're getting, and this varies by county, we're getting catch and release, meaning that if you are arrested for possession of less than 2 ounces of marijuana, you will be ticketed. You won't be taken to jail, you'll be ticketed. Now, you'll have to go to trial, but you won't be spending the night in jail. Some counties do catch and release and then will divert you for first offenders. You do something like take a drug education class and you don't even have to go to trial. One of the most interesting things imaginable is something that happened in the last legislative session. The growing of hemp was legalized in Texas. Now, what makes that a problem is hemp and marijuana, of course, are related. It's very expensive to test to see whether the substance that you have is marijuana or hemp. So some prosecutors are saying they won't prosecute for small amounts of marijuana. It's not worth the expense. It's I think, an amazing case of unanticipated consequences. Doesn't seem like the legislature anticipated it at all, that legalizing hemp would affect marijuana prosecutions. But it really has in a number of counties. In Travis County, now remember what we said about Collin County and what's being done in Collin County with possession of small amounts of marijuana. In Travis County, you're likely to get a ticket. Your punishment is likely to be a 4-hour class and a $45 payment and no criminal record. In Collin County, you get a criminal record. In Dallas County, if it's a first-time offense with no weapon or sale of marijuana, if it's not in a drug-free zone, there's no prosecution at all. In Harris County, if you are arrested for 4 ounces, not 2 ounces, but 4 ounces or less, you take a 4-hour drug education class, and that's the extent of your punishment. So things are changing regarding marijuana laws. And when you look at these numbers, maybe you'll ask yourself, well, why are Texans pursuing these marijuana laws to begin with? In 2017, To me, this is an extraordinary number. In 2017, 64,500 people were arrested for possession of marijuana. That was half of all drug possession cases in that year in the state of Texas. Harris County says once they started diverting people from jail to a drug education class, they were diverting 10,000 people a year from jail to drug education classes, and it was saving them in terms of jailing expenses and prosecution expenses and police resources. It was saving Harris County alone $27 million a year just to divert people from marijuana prosecutions to a drug education class. As you know, 10 states and the District of Columbia have already legalized small amounts of marijuana. 13 others have made it a civil offense. Texas came close to doing it. In the last legislative session, the Texas House of Representatives passed a bill that would make the possession of small amounts of marijuana a Class C misdemeanor. It's like a speeding ticket. What happened that was the problem is Lieutenant Governor Dan Patrick said, we're not going to hear this in the Texas Senate. And so the Texas Senate didn't even get a chance to vote on that bill, even though it passed in the Texas House 98 to 43. Bipartisan vote, Republican and Democratic vote. But this issue is going to come back again. Marijuana will be another big issue in the Texas legislature in the next legislative session. Another area where I think Texas is really moving toward justice is the repeal of a law called the Texas Driver Responsibility Law. It must have been, in terms of making criminals, it must have been, along with the marijuana law, one of the most ridiculous laws the state of Texas ever had. It began in 2003. It was repealed in 2019. You have to pay a surcharge under this law on top of your fines for traffic violations like driving without insurance or driving while intoxicated or getting 6 points in a 3-year period for minor traffic tickets. And if you don't pay, you get a suspended driver's license. And of course, if you drive with a suspended driver's license, you get arrested and you're criminal again, and you have to pay more surcharges again. And that was what was happening. This is just a list of the surcharges that were imposed. Invalid driver's license, $250. Driving without a license, $100. First DWI, a surcharge on top of your regular fine of $1,000. 60% of the people who got these surcharges didn't pay, which meant that Texas had 1.3 million drivers with suspended driver's licenses because of this law. It also encouraged people, of course, to plead not guilty in drunk driving cases, because if you were found guilty in a drunk driving case, you had to pay a huge surcharge on top of your fine. So this was just creating people, creating large numbers of people who were driving with suspended driver's licenses, unable, because of poverty oftentimes, unable to pay the driver responsibility surcharge. Well, as a result of repealing this law, 635,000 Texans will be able to get their licenses back. Another 350,000 will be able to once they pay a $100 reinstatement fee. This law had been on the books for 16 years. And what was it doing? It was just making people criminals. People couldn't pay the surcharge, but in Texas you have to drive. So you're driving with a suspended license, you're getting arrested, you're having to pay another surcharge, you can't pay the other surcharge, and it just escalates, just escalates. I wanted to talk to you as well about a new development in Texas that I think is quite extraordinary regarding the central role of the district attorney. I think the most important county official in Texas is really the district attorney. This, by the way, is just an ad from a district attorney's campaign. But here's the importance of the district attorney. The district attorney decides what you're going to be charged with. The district attorney or the assistant district attorneys who work for the district attorney plea bargain. The district attorney or the assistant district attorneys present cases, usually felonies, to a grand jury. And remember, you have no right to appear before a grand jury in Texas. Your lawyer has no right to appear before a grand jury in Texas. So the only one appearing before a grand jury is the district attorney or the district attorney's assistant. And the district attorney can influence courts because the district attorney is very political and can encourage opposition to judges. Criminal court judges often have backgrounds. Just look at Dallas County. Criminal court judges often have backgrounds as prosecutors or assistant district attorneys. So these are very powerful officials in Texas. But we're getting new district attorneys. This is one of our new district attorneys. This is Mark Gonzalez. He is the newly elected district attorney of Nueces County, Corpus Christi, Texas. He's a former member of a biker gang, as you might be able to tell from his appearance. In fact, before he was elected as district attorney, he was called the biker lawyer. But he's gone into Nueces County, he's gone into Corpus Christi, and he's really reformed criminal justice in Corpus Christi. He's using catch and release, ticketing people rather than jailing people. He's asking for lesser sentences for nonviolent crimes. He's proposing alternative sentences like halfway houses and probation more. He's changing the criminal justice system in Nueces County. And we have, they're not biker district attorneys, but we have reformed district attorneys who've been elected in Bexar County, where San Antonio is, Harris County, where Houston is, and here in Dallas County. And so you're getting changes in the criminal justice system because you're getting reformer district attorneys, at least in the larger counties, who are being elected. And they're changing the system, and I think moving us more toward justice, to come back to our initial theme. One problem area, I think, that we still have, although I think Texas is working on it, is legal representation for indigents. Generally in Texas, and there are exceptions to this, but generally in Texas, the way indigents get lawyers is judges assign a lawyer to the indigent person to represent them at their trial. The problem is compensation for those lawyers can be incredibly low. Bexar County, where San Antonio is, for a state jail felony, that's a pretty serious crime. State jail felony, Bexar County pays $75 an hour to a lawyer. For a second-degree felony, $100 an hour. First chair in capital case, the lead defense lawyer in a capital case only gets $150 an hour in Bexar County. It's even less in Fannin County, where Bonham is, $125 an hour there. Compensation is pretty low. Just to give you an idea, of how low this compensation is. I had a civil legal problem a while back. It involved an easement. I thought I owned an easement, a right to go across property, and the property owner thought I didn't own the easement. I had to hire a lawyer to work on this case. Ultimately, the person decided, yeah, you do own the easement. But I had to hire a lawyer before the person said, yeah, you do own the easement. I paid that lawyer $400 an hour for a pretty routine, run-of-the-mill kind of civil case. It was $400 an hour. For a capital case in Bonham, Texas, the chief lawyer is getting $125 an hour. And yet, there's some odd things. Using Collin County as an example. There's a lawyer in Collin County who made $460,000 last year representing indigents. $460,000 representing indigents. He billed the county 3,910 hours representing indigents. To give you an idea of what that is, if he worked a 40-hour week, last year that meant he worked 91 weeks. That's pretty impressive to work 91 weeks in a year. Just as a way of comparison, if you work for one of these big law firms, one of these really big law firms, 500 lawyers, 1,000 lawyers, that kind of law firm, and you're an associate, you're usually expected to bill 2,000 hours a year, and that's exhausting. That's why if you work in a big law firm, you burn out usually in 5 or 6 years, because you're billing 2,000 hours a year. This lawyer is billing 3,910 hours a year. In Harris County, you've got similar problems. In Harris County, their lawyers, 5 lawyers have over 400 criminal cases in a year. Ordinarily, you wouldn't want to have more than about 100, 125 criminal cases a year. To have 400 criminal cases a year is enormous. One of the lawyers in Harris County had 583 felony cases in a year. That's mind-boggling. In the past 5 years, he's made $1.54 million representing indigents in Harris County. Of course, one of the things you'll notice, the lawyers that get these kinds of big appointments, that they're very generous in their campaign donations to judges in that county. Maybe there's a connection there. But there is an effort even there to change things. In Harris County, in misdemeanor courts, what they're now doing is randomly assigning lawyers to cases, as opposed to having the judge pick a lawyer and assign cases. That would change this corrupt system a lot. So we're moving toward justice, maybe very slowly, but we're moving toward justice even in that area. I wanted to close with one thing that is just near and dear to my heart, and that is the Innocence Project. That is people who are found guilty of major crimes, who are sentenced to prison, and lawyers who work to find that these people are actually innocent. Now, we're not talking getting people out on a technicality. We're talking about proving these people are actually 100% innocent. And there are a number of lawyers that have been working on this since the late 1980s. Since 1989, there have been 2,468 exonerations. 2,468 people found absolutely innocent, even though they were imprisoned for crime. Some of them very serious. In Texas is the record holder. We have 363 exonerations in Texas. In fact, I think we have a couple more that just happened last week, so it's probably something like 365 instead of 363. We have a class, and if I can give a pitch for the University of Texas at Dallas, we have a class at the University of Texas at Dallas called the Innocence Class, where we work with the Innocence Project of Texas, reviewing cases of people who send their cases and say, I'm innocent, help me out. And our students review those cases with an Innocence Project lawyer and try to see if it's worth taking. One of the problems you run into is when you're in prison, you try everything to get out, and so you get literally hundreds of people who say they're innocent. But that doesn't mean they're innocent. And so you've got to sort of screen those cases. And that's what these students at the University of Texas at Dallas are doing here. Screening cases to see is this possibly an innocence case, or is this just someone hoping to get out of prison? The big case that changed so much about exoneration of the innocent in Texas was the Tim Cole case. Tim Cole was a student at Texas Tech University. Texas Tech University was having a series of rapes. There was a serial rapist at Texas Tech University, and Tim Cole was arrested for being the serial rapist. He wasn't. He died in prison. He actually had an asthma attack that turned into a heart attack, and he died in prison. But he was exonerated based on DNA evidence. He was exonerated after his death. And the actual rapist was found based on the DNA evidence. The actual rapist was found, but of course it did not help Tim Cole's situation. But Tim Cole's mother and Tim Cole's brother really became an organizing force in developing an organization called the Innocence Project of Texas, where lawyers work on innocence cases and try to exonerate people. This is also a very famous case. This is the Ken Anderson on my far right and Michael Martin on my left. Michael Morton was convicted of murdering his wife. Ken Anderson was the prosecutor. Ken Anderson withheld evidence that was exculpatory evidence, and Michael Morton was in prison for years. He received a life sentence. He served from 1987 until 2001, when finally courts ordered his file to be opened, and this exculpatory evidence was found. The other thing that was found was DNA found the actual murder of Michael Morton's wife. I was very pleased, and I think that Ahad came. I was very pleased to have Michael Morton come and speak at the University of Texas at Dallas a couple of years ago. Remarkable, remarkable story. But the interesting thing about this was the prosecutor, who had become a judge, Ken Anderson, was prosecuted for withholding the evidence against Michael Morton. Now, he only served something like 5 days in jail. But this was the first time a prosecutor had ever been convicted of violating the rights of someone he was prosecuting. Ken Anderson also had to resign as a judge and lost his law license over this. So this is a big case because it's sort of a turning point. It's a warning to prosecutors not to prosecute someone without being fair to that person. You have to turn over exculpatory evidence if you have that exculpatory evidence. And there was an enormous amount of exculpatory evidence in this case. Well, the big problems that have led to the conviction of the innocent, obvious one, mistaken identification. We worked on an innocence case, by the way, where a woman accused a man of rape. He was convicted of rape. After serving in prison a few years, DNA showed he was not the rapist. The woman continued to insist he was the rapist. It's a mistaken identification. In spite of overwhelming evidence, DNA evidence that he wasn't, she was convinced he was. She wasn't going to change her mind about it. Another big problem is snitches. One of the big things in Texas is if you're in jail, don't talk to anybody, because there will be people in jail who will go to the jailer and say, he just confessed. I'll testify at trial that he just confessed to a crime. And people have been convicted because these people have snitched. And of course, these people get a better deal from the prosecutor if they do snitch. That's been a big problem. Another big problem is just police focusing on a suspect too fast, not looking at alternatives. Another problem has been junk science. One of the big things for a while was bite marks. That you could identify a criminal by, if the criminal had bitten a victim, you could take that bite and identify the criminal by looking at their tooth pattern. It's crap. It's not true. It's junk science. And that's been a problem that has led to the conviction of the innocent. Official misconduct, like Ken Anderson's action as a prosecutor, have been a problem. And just having bad lawyers is, of course, a problem. One thing that has really changed in terms of innocence cases is DNA is no longer getting people out of prison anymore, because DNA analysis is now being used in cases where DNA is useful, often rape cases, sometimes murder cases. DNA is kind of becoming part of police and prosecutorial investigative techniques. So DNA is dying out. But what Texas just did is passed a law about snitches that I think is really, really important. You can't just convict someone on snitch testimony anymore. There has to be additional evidence other than the snitch. That is a really important thing. The other thing is the prosecution now is required to let the defense lawyer know what deal did the snitch get for snitching. That is a very important thing as well. So again, we're moving slowly in that direction, but we're moving toward justice. We're dealing with the problem of snitches. We're dealing with the problem of official misconduct. Ken Anderson losing his law license and being briefly put in jail. So there really is an effort to improve the situation for the people who are convicted but are actually innocent. So going back to Ahad's initial theme about justice and injustice in Texas. There's certainly a lot of injustice in Texas, but I do think these developments show a movement in Texas, a movement toward fairness, a movement toward trying to find greater justice in the state of Texas. And with that, let me close. If we have time for questions, I'd be glad to respond to questions. Yeah.
I think with the reforms throughout Texas history, particularly Whitmore Magnet reforms, it's showing a trend towards rehabilitation and reintegration of criminals and away from retribution. A few case studies that I personally point to is the prison systems in progressive countries like Norway, particularly Holden and Basel, that have a recidivism of less than 50% of the cases, where they treat their prisoners in more of a community-centered type prison system. Do you have any opinions?
Yeah, Texas has not moved toward that yet.
Yeah. Is that a model
but,
that we should strive for?
remember, we are moving toward at least incarcerating fewer people in prison. And that's a big change for the state of Texas. It's certainly not a Norway level change, but it's a very, very big change. Many years ago, when I was an undergraduate, this was many years ago, I was an intern in the Mississippi State Senate. And the big thing that year was eliminating the lash. They were still tying prisoners at Parchman Prison in Mississippi to the whipping post and whipping them. And the big thing was eliminating the lash, eliminating the whip. And we all thought that was such a big, big change in prison reform. Well, we've gone past that, and in Texas we've gone past that. We're putting fewer and fewer people in prison. I think that's at least progress. But we're a long way toward the Norway system. And quite frankly, I doubt that Texas will ever get close to the Norway system.
Do you have an opinion on the efficacy of it? Is that something we should try to?
I would be happier. I'm an incrementalist, and so I'd rather go for reform in little steps than try to go for a big dramatic reform like Norway, because I can't see it happening in my lifetime or your lifetime in Texas. But the little steps, I can see those things happening. More halfway houses, for example. More mental health treatment, for example. I mean, right now, the Texas prison system is the biggest mental health hospital in the state. If we can offer more incremental steps, I think that's where I would go. That would be the direction I would go. Any other questions?
In the back here.
Oh,
Right.
I'm sorry.
Can you speak a little bit about the monetization in prison and like private prisons in Texas?
Oh, one of the, let me speak from the standpoint of my bias here. I think private prisons are just an absolutely horrible idea. If you look at the inmate abuse cases that have been popping up in recent years, overwhelmingly they're coming out of private prisons. I just can't see profit-making organizations as being the ideal place to rehabilitate people who are convicted of crimes. And what you are seeing is just a great amount of problems regarding abuse of inmates. You may have seen the series, I think it was about a year ago, in the Dallas Morning News about inmate abuse in private prisons. It was horrifying. I mean, prisoners dying, prisoners who had diabetes, who were being denied insulin and dying. And overwhelmingly, it's the private prisons. Because the goal of the private prisons is not rehabilitation. It's not even safe incarceration. It's profit. So I realize this is a biased statement, but I'm really anti-private prison. Anything else? Yeah.
November 20th, we have a man slated for the death penalty. Rodney Reed.
Yes, yes.
Is the Innocence Project working directly or indirectly with his exoneration?
I don't know. We at the University of Texas at Dallas, we would never do a death penalty case. All the cases, and we have done an enormous number of cases, but all our cases were incarceration cases. We wanted to stay away from death penalty. That was just, I mean, we're talking undergraduate students. Screening these cases, my feeling is life is too important to leave it to a group of a dozen undergraduate students, some of whom are excellent and very conscientious, and some of whom are not quite conscientious. So we never worked on a death penalty case. Now, we did work on some pretty serious cases. We worked on some murder cases. Actually, one of our students was very involved in a case in South Texas where a woman was convicted. I can't remember if she got life or something like almost life, 50 years or something like that. She was convicted of burning her uncle to death by setting a fire that burned him up. And she worked on a case where basically the Innocence Project proved it wasn't a set fire. It was an accidental fire. The man who burned to death was a smoker who fell asleep smoking, and sleeping on a sofa, fell asleep smoking. We brought in fire experts who examined the death scene and said, this isn't a set fire. This is a fire caused by someone who fell asleep while they were smoking. So, and that person was exonerated. So we actually have had students, that student in particular, who had a major role in an exoneration, but we've never done death penalty. But Rodney Reed is a fascinating case. I hope all of you follow whatever happens one way or another in that case. It sure seems he's got a strong case for innocence, but we'll see.
Is it likely that he's going to get his commutation like Governor Abbott in the 7 days that he has left,
Well,
with the public opinion swaying the way it is?
yeah, it's kind of hard to tell. Governor Perry and Governor Abbott, I think, have both sort of gone both ways, sort of very pro-death penalty, but there have been moments where they've been persuaded by a particular case, and so they've at least commuted the sentence. So I wouldn't want to predict. I mean, I think it's possible. Remember, Abbott, before he was governor and before he was attorney general, was a Texas Supreme Court justice. Now, they don't deal with death penalty cases. It's the Texas Court of Criminal Appeals that deals with death penalty cases. But he has a judicial mindset. And so I think you'll pay close attention to it. But I'd hate to predict how he'd come out. Anything else? Yes?
Professor Champagne, I want to thank you for
Oh,
having
thank you.
Michael Morton, and I was coming here today, but I, along with Ahad, had a chance to attend that presentation a couple of years ago. It was very, very great. I enjoyed that. My question has to do with public defender offices in Texas. You know, in Dallas County, we have the public defender's office. I do a little bit of criminal representation, and you know, I sometimes get a case that, you know, the earlier part of the case or the previous case, that defendant dealt with a public defender, not so often in a good way. But in the larger counties, that is an answer to the criminal appointment concerns that you've raised. I think Harris County has a new public defender's office. So I'm just wondering what your opinion is of the concept of the state paying someone to defend a criminal defendant. At the same time, the state's paying for the prosecution of the same person. Do you have an opinion?
In Texas, public defenders' offices so far have been pretty small. They're pretty small offices. There's not, some states have gone into public defenders in a very, very big way, where there's essentially no assigned counsel anymore. But Texas has been sort of small scale on public defenders. The problem with public defenders, and you see this in particular in places like New Orleans, the problem with public defenders is an overwhelming caseload, where we sort of laughed at the caseload of some of these assigned counsel that had 400 and 500 criminal cases. But in some public defenders' offices, like the public defender's office in New Orleans, these people have caseloads of 1,000. And when you have an overwhelming caseload, you can't do anything other than sort of wholesale plea bargaining, wholesale plea people. That kind of public defender's office is undesirable, and of course doesn't move us toward justice at all. If you go to a public defender's office, I think it's got to be a public defender's office that is adequately funded with reasonable caseloads. And the problem is, in so many parts of the country, they're not adequately funded and they don't have reasonable caseloads. The worst example is New Orleans, but nevertheless, you see that in other parts of the country. I think that is really the big problem with public defenders' offices. There was a very famous legal scholar a number of years ago who wrote a book about indigent defense, where he interviewed prisoners and he asked the prisoner, "Did you have a lawyer?" And the prisoner responded, "No, I had a public defender." We want to avoid that kind of situation, and that's the big danger with public defenders' offices. Anything else?
You made a comment about the process by which public defenders are appointed. And that there's
Assigned counsel.
Right.
Yeah, not
Right,
public
and there's an
defender.
inherent conflict of interest there when a judge needs to run for a campaign and takes these folks for campaign donations. Would you care to talk about the merits of that system or an alternative system that Texas probably should look at?
Well, one alternative system that's being tried in misdemeanor courts in Houston is just randomly assigning lawyers. But the problem of electing judges is one of the big issues in Texas, and it's been around for years and years and years as a big issue. There's a possibility that will change in the next few years. I'm not sure it's going to change, but at least there's a possibility. But the problem with electing judges is, to run for office, you need money. Where do you get campaign contributions to run for judicial office? Basically, if you're running for judicial office, you get those campaign contributions from lawyers who appear before that court, or from interest groups that have an interest in that court. For example, if you are running for the Texas Supreme Court, Texas Supreme Court is not a criminal court. The Texas Supreme Court is a civil court. It only hears civil cases. But it hears some big-time civil cases. Where are you going to get your money? You're going to get your money from plaintiffs' lawyers who sue insurance companies in civil cases, and you're going to get your money from insurance defense lawyers who defend those insurance companies in civil cases, and you're going to get your money from businesses that are being sued. Does that create a conflict of interest? Does it create a bias? I think it does. I think it does. One of the best examples, if I could go back many, many years to the 1980s, one of the best examples was a plaintiff's lawyer in San Antonio who gave a $100,000 donation to a Texas Supreme Court candidate. $100,000 donation, where that Texas Supreme Court candidate's total contributions were $550,000. Do you think that's a conflict of interest, that almost 20% of your campaign contributions comes from one lawyer who has cases before your court? So that's the big problem with electing judges.
Our judges in a situation like that are not required to recuse themselves from cases.
No, they're not required to recuse themselves. So that judge could get that $50,000 contribution, or that $100,000 contribution, and still do that case. Has no effect on my thinking. I have a judicial mind. I'm not concerned with who donates to me. Or so the judges say.
All right, we have time for one last question, if there is one.
Yes.
What do you think is the next step for reforming Texas prisons?
The next step in reforming Texas prisons?
Yeah.
The next step is going to be providing air conditioning. One of the big problems in Texas prisons now is prison cells can get up to well over 100 degrees. And prisoners are even dying because of the heat in prisons. The next big reform, and admittedly it's an incremental reform, but the next big reform will be providing air conditioning in prisons.
Excellent. Thank you, Dr. Champagne.
Thank you.
I'll make a brief announcement.